I'd now like to invite ACJC to open the opposition case.
Testing? All right, great. Team Opposition would like to start off with two key clarifications before going on to prove why detention without trial was firstly lacking in legal and moral justification, and secondly anachronistic in addressing the threats that it aims to. The first clarification is that we are willing to modify the Constitution such that it evolves with the needs of the people. And therefore, our second clarification is that we would support slight adaptations of the conventional trial system, including a media blackout, to protect the identity of witnesses, as well as pre-trial detention and expedited warrants as governed by existing laws in time-sensitive cases. All these measures are already selectively being applied in the status quo. However, they still allow for trials to remain adversarial in their process. I'm going to be proving to you now on how detention without trial lacks legal and moral justification. The morality of detention without trial is put into question because it removes the rights of an individual to challenge his charge, and this is unjust. The accused's rights to a fair trial is crucial to the justice system as it is a key filter in the process of guilt determination. The nature of the courts is crucial to this, as it is a body that is specifically tasked with the power and the responsibility to interpret evidence with full neutrality. The moral justification behind this is that the country reserves the rights to curtail on the rights of an individual on the sole condition that guilt is proven to the best capacity of the system. This is particularly so for a system that has been proven to subject those assumed guilty to sleep deprivation, solitary confinements, beatings, harsh interrogation, where all rights and liberties are held in relation to the potential benefits of interrogation or the presumption of guilt. It is morally unsettling for a system to contravene on the most basic rights of an individual. It is clearly unjust to do so with an individual who has not had the opportunity to prove his innocence. The only check against the existing system of detention without trial is an advisory board that fundamentally fails to meet up to the adversarial nature of a court system, where individuals within the committee, including the Supreme Court judge that side proposition brought up to you, act only in their capacity as laypersons rather than neutral legal experts, and they are never obligated to prove guilt beyond reasonable doubt. We pay the price for a criminal trial system because we fear the alternative, which is quite literally a police state. Public liberty demands that the factual premises of the government's resort to coercion and force be laid out and tested in some adversarial process. While private liberty protects individual autonomy, public liberty protects collective rationality. An enabling condition for this public liberty is a form of accountable polity, in which rulers are held strictly responsible and accountable to those over whom they exercise power. The institution of criminal trial is a facet of this form of accountable polity, as it is based on a demand that the executive justifies its call for criminal censure and punishment in an open proceeding, when the accused has the right to challenge the charge and the adequacy of the proffered justification is judged by judiciary representing the citizenry. But moreover, constitutional elements which are particularistic in nature may clash with the principles of justice which are universalistic in orientation. Judges are therefore given the exclusive authority to interpret these constitutional principles in relation to the laws as a means to safeguard the integrity of the legal system within the country, within the bounds of the Constitution. This can be seen in an excerpt from the judgment on Cheng Suan-Zi v. Minister, which found that, and I quote, Section 8 and 10 of the ISA are exceptions to the fundamental rights guaranteed by Article 8, 13 and 14 of the Constitution, and should therefore be narrowly construed so as to derogate as little as possible from such fundamental rights, end quote. Hence, due process through the trial system is essential to the validity of the charge, the integrity of the legal system, and the rights of the accused. But then on my second point, on how detention without trial is anachronistic and ineffective. In the recent presidential debates, President Tony Tan recognized the nature of the ISA as a blunt tool, acknowledging the inherent flaws of this method of detention without trial in targeting modern evolutions of the problems it sought to address in the past. Today, other laws are better able to tackle specific concerns of the ISA and CLTPA. Side proposition has claimed a need to react preemptively. But existing laws already allow for this in the trial system, as the trial system can be used to prove a spectrum of mens rea, prosecuting on intention to commit prior to the act. Regarding the threats of terrorism, the Terrorism Suppression of Financing Act and Terrorism Suppression of Bombing Act imposes harsh sentences, including the death penalty, on any individual found guilty either directly or complicitly in the act of terrorism. It also addresses the ability for cross-border protection of Singapore's internal security by acknowledging and affirming Singapore's commitment to the International Convention for Suppression of Terrorist Bombings, which makes provisions for extraterritorial jurisdiction, allowing for ease of extradition of suspected terrorists to be tried and jailed in Singapore. The Preemptive Strategic Goods Control Act is similarly proactive in nature, as it enables certain bodies to track and bar entry of certain substances that are identified to be commonly used in bomb making. Adjusting arrested terrorists as common criminals who undergo the same trial system are far more effective in addressing the terrorist threat, as it normalizes their rhetoric as martyrs who are fighting against an oppressive state symbolized by detention without trial. Regarding ethnic conflict, the Maintenance of Religious Harmony Act is effective in preventing sedition to religious harmony, and it empowers the judiciary to issue restraining orders against individuals who threaten religious harmony, and gives clear guidelines as to the punitive punishments of the breach of ethnic and religious unity. This is similarly seen in the Sedition Act that aims to address cases of espionage. But moreover, the CLTPA has been recently used to deal with drug trafficking, secret society and loan sharking, as Proposition rightly pointed out. In response to drug trafficking, the Misuse of Drugs Act proves a severe deterrence for any potential drug trafficker because of the institution of the mandatory death penalty. When dealing with secret societies and loan sharks, Sections 148 of the Penal Code punishes those found guilty of rioting with a deadly weapon to up to 10 years in jail and liability for caning. The Money Lenders Act targeted illegal money lenders and has led to a fall in cases of illegal money lenders by 9.7% from 2009 to 2010, as reported by Law Minister Mr. Shanmugam. This is more effective in addressing drug syndicates, as the detention of syndicate kingpins without trial creates a self-selecting mechanism where only the most brutal and powerful kingpins will be able to escape detection, effectively exacerbating the drug crisis. This is the counter effect created when using detention without trial to combat the drug scourge. The efficacy of detention without trial was unique to a period where Singapore was in the most primary stages of independence, where a stable and effective law enforcement and intelligence network was still being developed while external threats were growing in prevalence. The evolution of Singapore's home team, the advent of technology and interstate communication, and the evolution of laws which are targeted in nature enables due process and are a far more effective tool in addressing the same concerns that the outdated method of detention without trial sought to. In conclusion, we have demonstrated the non-congruence between detention without trial and legal principles, as well as the failure of these anachronistic mechanisms in dealing with modern threats. That's why detention without trial is not justified, and we will not let it stand.
The speaker spoke for 8 minutes and 9 seconds.